New at 4, Maricopa County Attorney Rachel Mitchell is speaking out on teen violence in the Valley after the stabbing death of a student at Maryvale High School.
Happened right in a classroom at that school. 12 News journalist Sean Rice live outside the county attorney's office. What you have to say today, Sean?
Yeah, Troy and Tram, good afternoon to you both. In the wake of that level of violence that happened inside a West Phoenix classroom this week, I asked County Attorney Rachel Mitchell pretty plainly, does she believe teens are doing okay here in the Valley? She responded saying no, and she used that incident inside a Maryvale High School classroom this week as an example of criminal behavior involving teenagers that she said is of great concern to her. Now, we did obtain some court records in this case, and those are giving us greater insight into what may have happened inside that classroom on Tuesday. Now, Phoenix police have identified the victim in this stabbing incident as 16-year-old Michael Montoya II. The teen accused of stabbing him to death, now identified as his classmate, 16-year-old Chris Aguilar. Court records obtained by 12 News show that witnesses told Phoenix police that Montoya may have recently robbed Aguilar of a gun. Posts on social media indicate the pair met up for a, quote, deal the day before the stabbing took place. Court records say that is when the alleged robbery happened. Now, over the next 24 hours, from Monday to Tuesday, there were then threats of murder made against Montoya by Aguilar and his brother, according to court records. Classmates reported seeing Aguilar sit in a different seat on Tuesday in class right next to Montoya at Maryvale High. They reported seeing him take out a pocket knife and stab him 3 times. Aguilar is now charged in adult court here in Maricopa County with second-degree murder. Now, this is the message Maricopa County Attorney Rachel Mitchell gave to parents of teens who may be showing signs of criminal behavior.
Don't bury your head in the sand. And, you know, government, and I said this morning, I was at another function, government is a poor substitute for the family. And the family, when they see those early warning signs, you know, seek help, get resources for your kid, because you're ignoring it doesn't make it go away, and eventually it's going to really be problematic.
Now, Aguilar is being held in the Maricopa County Jail with a $500,000 cash-only bond. He will be back in adult court coming up this next week. Now, one thing to look out for in this case, and we asked Mitchell about it today, is a potential upgrading of charges from second-degree murder to first-degree murder. She said in response that, quote, nothing is off the table in terms of how they could present this case to a grand jury and a potentially upgrading of charges. The reason we asked that is because in these court records, there's some evidence that may point to what's called premeditation, that Aguilar may have thought about this for 24 hours, may have planned it out, and then allegedly carried it out in the classroom the following day. That is the bar they must prove in a first-degree murder case. We're live in Phoenix. Sean Rice, 12 News.
Yeah, there's also been some interpretation, Sean, that all you have to have is the idea, even during the commission of that crime, that what you're doing is likely to take that person's life for it to be premeditated. But I would imagine his age will also be a factor, so it will be interesting to see if it goes from second degree to first.
Yeah, exactly what you just mentioned, Troy. There's a lot of factors that they have to consider. This is the referred charge that Phoenix police sent to the Maricopa County Attorney's Office. So at least when it comes to probable cause, the Phoenix Police Department believes that there is enough evidence for second-degree murder, potentially not first-degree murder at this point in the case. Of course, the investigation is still ongoing. Send it back to you.
All right, Sean, thank you. Tram?
Let's take a legal deep dive into this case. Criminal defense attorney Josh Colesrue joins me now. So let's talk about that. The fact that this 16-year-old, again, a minor, now obviously being charged as an adult. Why wasn't he charged with first-degree murder? What would it take?
Yeah, whenever a prosecutor first gets on a case, he wants to make sure that, number one, that they can bring some charges, and hopefully a heavy enough charge where the bond is going to be high enough where they're not released. So here they charged him with the easiest type of homicide to prove in this case, which is knowingly killing another person, which is second-degree murder.
Mm-hmm. Do you think it will be upgraded then?
Yeah, so there's some indicators here that it will be upgraded. Number one, their witnesses say that both the brother and Aguilar mentioned the day before that they wanted to kill the victim in this case because they're alleging that the victim had robbed them of a weapon the day before. And Aguilar brought a knife to class and then attacked, this is again, according to the witness statements, attacked the victim from behind, and there's no indication that this is a self-defense scenario.
Okay, in a situation like this, though, when you have so many witnesses, it's been circulating on social media, it's been recorded, how would you defend this kid, this 16-year-old Aguilar?
Well, first of all, I would want to try to make the case that this was a fight that got out of hand and that it was not premeditated, that it was spontaneous. And even I would especially look for reasons that Aguilar thought that his life was in danger and that he had no other choice but to defend himself with a knife.
Okay. If he is convicted, what could he face?
So if he's convicted of second-degree murder, that is, knowingly killing another person, he will be facing 25 years in prison, but he has parole, or he can get parole after 25 years. If it's first-degree murder, without the death penalty, it is a life sentence, natural life, with never the possibility of parole.
All right. Let's get to our next case, the murder of 10-year-old Rebekah Baptiste. Police say Rebekah was killed by her father and his girlfriend in July, while the couple was already under investigation by DCS over abuse claims. Records show DCS was contacted at least 12 times before her murder. The first report dates back to 2015. Child safety workers visited the Baptiste home when Rebekah was just 8 years old. Over and over through Rebekah's short life, people filed complaints about alleged abuse and neglect, and over, the state did not find enough evidence to take action. Josh, we're talking at least 12 reports. Make sense of all this when clearly there's some kind of pattern here established. Why wasn't she taken away?
Exactly. And it's not just 12 DCS reports, it's also 5 additional police reports. And the issue here is that DCS can't look at the cumulative evidence and then group it together and use that as a basis to take away somebody's children. The standard is that there has to be a clear and present danger. It has to be happening right now in order for DCS to have that ability. And DCS can only do that as the extreme remedy, and they can only do it for up to 48 hours without a judge signing off on it.
So obviously the threshold is a lot higher then, right? Do you think that something like this, after what has happened, I mean, that maybe they'll take that cumulative approach?
Yeah, unfortunately, bad cases sometimes is what it takes to change policy and the law. And Rebekah here is obviously the victim because the policy doesn't work properly. I really do expect there to be a lot of discussion for DCS and the police to look at previous incidents and look at that cumulatively together to form a basis to protect the children.
Yeah, set the bar. All right. Rebekah's dad and his girlfriend, we know that they've been charged with first-degree murder, among other charges. Could he face the death penalty?
Absolutely. So the first thing that needs to happen is they need to upgrade the charges to first-degree murder. And then they have to find that an aggravating factor exists. And here you have 3. You have the age of the victim, who is a vulnerable victim under the age of 15. The father was in a position of control. And you also have torture or cruel and heinousness of the act. So there's 3 different reasons that the prosecution can use to elevate this to a death penalty case.
All right. It seems like every week we're uncovering more and more disturbing details. It's really, really unfortunate.
Yep.
All right, Josh, thank you so much. We'll check back in with you once again in our next half hour on the Menendez brothers.